We're about to Zoom live. Hello, everybody. Welcome back. How's everybody doing today? I hope you guys had a wonderful day. If you've been trying to message me, I've been away from the machine, helping my wife move stuff, open up another Airbnb. Yeah, she made me work hard today. So today we're going to talk about a couple of things. We're going to talk about the property taxes, but I got something more important to talk about. I want to spend a little time today talking about a couple of the main tricks that they use to boot you out of court. And one of the tricks that they use is allowing the magistrate judge to throw you out. And the magistrate judge does not have jurisdiction to be involved in your case without consent from all parties. And if you don't think I'm on target on that, go ahead and Google magistrate judge consent form in your state. More than likely, one or two spots down on the list, you'll pull up your court, your magistrate judge form on your court in your state. And you'll see that it says the magistrate judge does not have jurisdiction to be involved in the case without all parties' consent. And what they do is the magistrate judge, usually the district judge or sometimes even the clerk, will assign your case to the magistrate judge without your consent. And sometimes they mail you the consent form, but most people just throw that in the trash. And if you don't object, you're agreeing to acquiescence. The way they get away with that is they tell you, oh, well, the district judge is busy and blah, 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 blah. And so they get you to agree to do it by the pretenses that it's going to take a real long time for you to get into court if you don't. And as far as I'm concerned, that's fine with us because we ain't trying to go to court. But what you need to do, if the magistrate judge dismisses your claim without consent, then the magistrate judge didn't have jurisdiction to dismiss it. Everything goes back to the jurisdiction. Remember, everything goes back to the jurisdiction. And if the magistrate judge dismisses your claim without jurisdiction, then you would need to file a reconsideration package. And the reconsideration package is on my YouTube. The reconsideration package is on my website. But if you need it and you don't have it, and you made your investment into your lawsuit package, then just let me know and send me an email and your name, and I will send the package over to you. So hang on one second. Okay, so when the magistrate judge dismisses your case without jurisdiction, you want to go ahead and file your motion for reconsideration. The motion for reconsideration also has in it the documents that you need to recuse the judge. It has the documents you need. Well, first off, you want to file for reconsideration, which is like objecting. And then you want to file to recuse the judge. And then we have a document in there, which is a document, a notice of claim against the judge for violating your constitutional rights and violating the law by taking action in the case without jurisdiction. Now, that notice of claim can be the claim. All you have to do is just take that little word notice out and make it and replace it with $5.5 million or something. And now that's your lawsuit that you would file against the judge. So many times we get tossed out of court illegally and we don't even realize that we've been violated. And I think what they're doing by having the magistrate judge throw your case out is they're saving the district judge from having to worry about the issue of someone challenging it and holding the district judge responsible for violating constitutional rights or any other issues that you're going to jam up the magistrate judge with. So the magistrate judge does not have consent to be involved in your case without all parties' consent. And that's something that I'd want to have as an appeal issue. You want to make your appeal issues the problems of them violating the law. And that's the best way to put yourself in a position to make them not want to have the appeal. So if the magistrate judge dismisses your case, then you have an option. And I think we have a strategy in the lawsuit package to address that issue. If you guys don't remember what that is, you're going to have to go and check it out and check out the instructional video for the lawsuit package. And I want you guys to remember, so I'm a coach, and my job is not to make it easy for you. My job is to help you learn. So if you call me and you ask me questions that you should know by reading the document, or questions that you should know, by watching the video, I'm going to refer you back to the video. Because if you miss that, that could be the difference between them getting off from underneath the rock that you're going to be smashing them with. So be ready for that. I'll send you back to go look at the video before I give you, because like I said, my job is not to make it easy. My job is not to make this, not to save you time. My job is to help you learn how to get to stay in your house. And you guys have to put the time in studying the documents. And if you don't know, I'm not going to waste any time. Hey, Showtime, what's up, buddy? Good to see you. Yeah, I do need a whistle. The only thing is, when I blow the whistle, that means that everybody's running. Okay, I can't make everybody run, especially if I can't run. Well, I can run a half a block. So we're going to get back to the subject. We're talking about the magistrate judge's lack of consent. And this is a pretty important subject for people to be aware of, because if the magistrate judge dismisses your case, now you can focus on the magistrate judge. Because like I said in one of the other videos, it don't matter who it is you put or how many people you have that are blocking you, that you have listed on your lawsuit. Anybody that's blocking you from getting in court and having your day, it needs to be addressed. And so many times crap like that happens and people just don't know what to do, or they say, oh, the judge just, the judge just like screwed you over. So that's what the judge just did. And until we have a strategy in place to address these problems, people are going to have a hard time trying to get to the next step because of the misconduct. And I think that is one of the biggest difference in my program and what I help people learn here. If you don't have a plan to address that misconduct, then you're going to have a long day. Now, when I was doing the research for this magistrate judge lack of jurisdiction issue, because all parties haven't consented, my wife was arguing with me, and she knows a little something. She was arguing with me. She said, no, that's not true. The magistrate judge can do this and the magistrate judge can do that. And I was like, well, I'm pretty sure I saw, so I didn't say nothing. I didn't, so she's just chilling over there in the easy chair playing on her phone. And I typed in magistrate judge consent form, Texas, bam, pulled the form up. It was like the second one down on the list. Opened it up and it had right there, the magistrate judge does not have consent. And it shows the statute that he would be violating if he took consent without having, if he took jurisdiction without having consent. And so I was like, oh, so I printed it off and I handed it to my wife. I said, here you go, sweetie, this is for you. She said, well, what's this? And she looked at it and she read it. She said, oh my God, you're right. And I said, could you say that a little one more time, a little bit louder? She looked at me and cracked up laughing. Yeah, so the magistrate judge does not have consent, and they get away with this all the time because people don't know. And at the end of the day, who would consent to a lesser judge looking at your lawsuit? Yeah. And once you let them know that you're not going to put up with their misconduct, then things start to change. As a matter of fact, that in that reconsideration package where you're objecting to the judge's order and you're filing your motion to recuse the judge for giving the attorneys an unfair advantage and your notice of claim, when you get done filing all that, remember you have 10 days to do this stuff after the judge makes an order. When you get done filing all that, what I like to do is follow that up with my notice of appeal, right? Like a couple of days later. You don't want to give them a chance to answer to it. Stick that notice of appeal right in their face. And now when you file the notice of appeal, they no longer have jurisdiction. Oh, wait, they didn't have jurisdiction in the first place, but they thought they did, or they acted like they did. And now they don't have jurisdiction. So now all of that garbage that the judge has been doing is about ready to go to the appeals court so they can see how bad he's messing up. And I've had a couple of people do this and follow these steps, and they ended up letting them pass and not kicking them out of court. They just forgot about the fact that they already ruled to dismiss their case and allow the case to go through. It's funny how it goes. So Showtime, how's things going with you? I see you have 3 people watching. Who else is here? Make yourself known. So Showtime, have you seen my new course outline from a new online course? Yeah, real crazy times going on right now, Showtime. You got that right. And I know these attorneys are going to be, they're lying things up right now is what they're doing. And so that's why we're trying to help people get a handle on this stuff. Because I know pretty soon they're going to be lining things up, and all the people that sat around and didn't do anything right now, they're going to be the first ones that are going to be pushed to the edge of the cliff by these attorneys doing fraudulent activity. Thank you, buddy. I'm glad you think it looks great. Put a lot of work in it. Now I just need to get some people in there so we can start teaching some people how to do some more things. And the new online course has a jurisdictional challenge with an affidavit in it to actually blow the judicial foreclosure up before you file your lawsuit in federal court. So that's going to be pretty cool. A lot of the times they try to block us. Hey, John Boy Rains. So John Boy Rains says the ultimate goal is to settle with the servicer for pennies on the dollar. Then he's asking me, can one of your packages help force them to negotiate? So John Boy Rains, so the ultimate goal is to force the attorneys to pay you what you want, because the servicer don't have nothing to do with this. And we talked about that in the last feed. That's like the number one mistake that most people make, in my opinion, when they're fighting in foreclosure. They think the servicer or the lender is the one coming after them. You have to remember that attorneys lie when their mouth's moving. Okay, so you can't go into this fight using anything that you learn from the attorneys or anything that you use in the conventional program, because the conventional program was structured by the same attorneys that's trying to steal your property. Well, by their buddies, and they're all from the same gang. So you know where we're going with that. And if you think I'm off base on this, Johnny Boy Reigns, check your petition. You'll see either the petition if you're in a judicial foreclosure, or if you're in a non-judicial foreclosure, it'd be the notice of default letter. Check it. You'll see it's only signed by the freaking attorney. So if the attorney is the only signature on it, how could there be anybody from the bank suing you? Somebody from the bank would have to sign somewhere. And that's a problem. If you go by the signatures, the attorney is the only person on there that signed. And we have people in a Facebook group that have been harassing the lender, and the lender finally told them, look, stop bugging us. We don't have nothing to do with it. You need to call the attorneys. Well, we already knew that, because the attorney's signature is the only signature on the lawsuit document against your property. And I'll tell you this, when you stick that attorney's name on there as the number one defendant, and the attorney's law firm as the second defendant, and the last servicer, and that's it, now the water is not muddied. The attorney is the one taking responsible for everybody's stuff, and it's a problem. And when that happens, the attorney has to hire outside counsel, because the attorney can't represent himself, attorney can't litigate a case they're party to, and the attorney can't go into court representing the law firm pro se, which is what that would be considered. And when the attorneys try to find someone else to help them, it's a problem, because the other attorneys that they try to hire will figure out that the foreclosure attorney is being sued for unlawful foreclosure acting as a third-party debt collector. And the attorney is not going to want to be involved in that, because they're doing the same crap. So now you have a great appeal strategy, and force the judge to, because the judge is going to have to allow the attorney to represent everybody and all that. And now you're ready to, can I force the attorney to settle for pennies on the dollar? Johnny Boy Reigns. So, dude, I'm not going to send you into court wanting to settle for pennies on the dollar. When you file my lawsuit, it's for $5.5 million or more. You can add whatever you want to it. It's for $5.5 million. So can you force them to settle? Well, that's up to them if they want to settle. I'm going to try to force the court to make them pay me something in that range. So if you're going to roll with me, man, you need to think bigger than that. How about we make the attorneys go sit the hell down, and we file the jurisdictional challenge in their state court case and blow that up, and they're not able to answer to it. And then we can use that jurisdictional challenge as evidence in federal court by adding all of that you filed as exhibits to your lawsuit in federal court to show that state court didn't have jurisdiction from the gate, and then just ask them to just pay you, because it's going to be a waste of the court's time to have all this in court, a whole bunch of hearings and all this stuff, because the attorneys can't respond. Other thing that you're going to be addressing in your jurisdictional challenge with an affidavit is, one, the foreclosing statute does not have the necessary elements to be considered a valid law. Bam. And that's the fact. How you say thank you and you're welcome. They can't argue it. because the statute does not have the necessary elements to be considered a valid law. And the other argument that you're going to be making in your jurisdictional challenge with an affidavit is the fact that there are 6 things missing from the contract that they filed in the case against your property. And those 6 things are in the original contract. And if you read the jurisdictional challenge and understand what those 6 things are, you will know how powerful they are. And your jurisdictional challenge with an affidavit is going to force them to have to produce that original contract to dispute what you're saying. And what you're saying is the 6 things that are missing are the things that should have taken place during the transaction, during the deal in the first place. And if they deny them, they're going to be in trouble. If they admit that they did them, they're going to be in trouble because they didn't do it. So that's pretty powerful. And when they can't respond to that and the judge has to dismiss the case or whatever, then you're going to be using that as evidence in your lawsuit in federal court. Nice little way to stack it up on them. So John Boy Rains, one of the things that we're doing now, the changes that I made, I haven't put these changes in the documents yet because I just haven't had time. But one of the things that I've done in the last document that I helped someone with, what we did was we added in the document that we're going after the 5.5 in damages, but we're also going after the attorney's assets. Yeah. His house, the car, we're going after the assets. And that's going to give the attorney an opportunity to see how it feels to have someone trying to steal your freaking house. Yep, and you can do that. So I don't worry about trying to force the attorney. I like to just keep smacking them in the face. That's how I like to roll. I like to keep smacking them in the face. I like to make them give up. If they ain't gonna give up, then we're just gonna keep right here smacking them in the face, like we're gonna be doing. So that's how I do that. And yeah, you can use my lawsuit package to do whatever you want, whatever your goal is, but I'm not worried about settling for pennies on the dollar because they're not going to be able to respond to none of the stuff. Now, if you go with the lawsuit package, you still have a challenge of jurisdiction in there that's pretty powerful, and people have been using that to get control of the foreclosure before I put together an online course. So, and if you're in a non-judicial foreclosure, the package also has a strategy in it to actually remove the eviction process, to block the eviction process and remove the eviction process from eviction court over to be connected with your title dispute. That title dispute runs the show, and especially if it's in a higher court. So if you use my documents and you get that filed, when you're talking to those fools in court or the attorney, you want to always refer to your lawsuit in federal court as your title dispute, because the title dispute is what controls the show. Eviction court cannot make a determination on a title dispute, only immediate possession. And the problem is immediate possession cannot be determined until the title dispute has been settled. Got to keep it simple. Yeah, Showtime, I came up with that one night after I was shut everything down and laid down in bed. My brain was still going 50 miles an hour. Showtime said that he likes the info on going after their assets. Yeah, that ought to get their eyeballs open up and see that you ain't playing after the 5.5 million and their assets. John Boy Rain said, that's savage. Yep, that's how we roll. And I love my job. You'd be surprised. In that lawsuit package, if you invest in that lawsuit package, you'll have a sanction motion in there. And these attorneys are supposed to do a reasonable pre-file investigation before they file all this stuff. They never do. And if they don't, they can be sanctioned. If they keep coming after you and you prove that their claim is baseless and they continue to attack you, they can be sanctioned. So we use the sanction motion as kind of like a little lawsuit inside of the big lawsuit. And the sanction motion, I like to save it until, if they find some other attorney. I had a guy who had an attorney from out of state come in to try and take control. And so we slapped him with the sanction motion, and I don't know, he must have went back home because he didn't file nothing else in the case. They have a hard time finding attorneys that want to help them when they're getting the stuff that we structure stuck in their face. They're having a hard time finding people that want to help them. Yeah, Showtime says he's laughing. My mind's always going. Yeah, it is. I have ADD mind. It's always going. But being a coach and being in sports most of my life, I can see things and think about things that most people don't pick up on, and that's helped me help a lot of people. And having the courage to step up to the plate, because they tried to shut me down a couple of times already, and I got a bunch of haters that follow me around. Well, they kind of shut up because I don't play that crap, and they want to get in my face. Then I hope they brought a lunch, because it's going to be a while. And I haven't had anybody been able to challenge me. This unlawful practice of law without a license. There ain't no such thing. And under Swear versus Board of Examiners, the Supreme Court's ruled no state can license the practice of law. Anyway, I piss attorneys off all the time because I'll tell them, so you have a license to practice law? Could you text me a picture of it? I'd like to show it in the group. And I'm not talking about your bar card, because all that is just entry into a club for paying dues. Yeah, they get. One attorney told me that I'm misapplying the case law from the Supreme Court. So I told him, I said, well, I'm not as smart as your attorneys. Maybe he could break it down for us right now. Yeah, click. He didn't have no more to say. So if any of you guys are facing foreclosure, I'll tell you right now, if you're struggling with finances, with income, that jurisdictional challenge with an affidavit is still on the website for like $200. And when my online course fills up, then I'm going to actually, it's not on the website. So you would have to email me for it, and then I'll send you a link to make the payment, and then I can send you the document to your email. I didn't post it on my website because it's going to be, it's the specialized document we're using in the online course. So I didn't want to have it for everybody on the website too, because that wouldn't be fair to the people that are paying the premium price for the videos and the guidance and stuff that you're going to get in the online course. So I'm wondering how I can do the share window. I'm still learning how to run this program. So the other thing that I wanted to mention before I wrap up is, and I mentioned this yesterday, but I'm going to mention it again because it's worthy of mentioning every time we talk. When you guys go to file your documents, if the clerk gives you a hard time, what you want to do is you want to ask for the supervisor, and then ask the clerk's supervisor if the supervisor has authority to make a legal determination on your documents. And you'll find out that they don't. Only the judge does. And we have one member, and I think he was from Georgia, and he took his, this is before all this lockdown stuff started. He took his documents in and he filed everything at the same time, including the sanction motion, which you don't want to do. You want to give them one document at a time, especially if you're planning on filing a sanction motion, so they can't like use that and start tripping on it and try to block you. So he filed everything at the same time, and they came back and they just told him they weren't going to file his stuff. And he told them that, well, he already gave them his stuff, and I'm on camera right there giving you guys my stuff, so you can do whatever you want with it. So the clerk supervisor took all of his documents and threw them in the trash can. And yeah, the dude was black man, so I figured they probably was trying to see if they can, agitate him and so they could, give him a hard time. So what he did was he just went on, he just left. And he wandered around in the building because he was going to report them to the prosecutor. But that's what he was going to do. I was like, dude, that's not going to help you because the prosecutor don't care. But he said he went out and got in his car and he's sitting there smoking a cigarette because he was still kind of pissed. And they called him. They called him on the phone. And they told him that they're going to go ahead and file his documents because they had talked to a pro se attorney, and the pro se attorney told them that they had to file his stuff. And I was like, a pro se attorney? Are you kidding me right now? I started laughing. He's cracking up. He said, yeah. I said, man, that's the best they could do, a pro se attorney? What the hell is a pro se attorney? No such thing as I'm bringing pro se attorney. You got to be kidding me. But yeah, they had to file this stuff. And he said they were pissed. But you know what? That's the way it goes. If you want to be dirty, you need to be ready for someone to throw that dirt back in your face, because that's pretty much what we're going to be doing here, is throwing that dirt back in their face. So, John Boy Rains, are you thinking about investing in the program? And I was hoping Frankie 5 Times was going to be on tonight. I see she invested in one of the packages, and I wanted to ask her what she thought about it if she had a chance to look at it. So I wanted to try and keep this about 30 minutes tonight because I've got some other stuff to do. So, and I'll probably be back on here tomorrow. I don't really have a whole lot going on the weekends. So you guys can look for me tomorrow after 9 o'clock. That's the best time. Everybody's kind of settled down, drinking that glass of wine. So that's what we're going to do. I'll be on tomorrow, and I'll see what we're going to talk about. I will let you guys know tomorrow. So thanks for listening, guys, and I'll see you guys tomorrow. Oops, I got someone to send in a question. No, they just gave me a couple of nice compliments. That's cool.